Well, good morning, everyone, and welcome back to AJ111 Criminal Procedure. My name is Tony Farrar, and of course, I am your instructor for this semester. This morning's chapter lecture is going to be Chapter 12, where we are going to look at the legal process, including the initiation of the process, bail, and also the right to counsel. But we're also going to spend a little bit of time on something called prosecutorial discretion, that discretion to charge. So before we get into this morning's lecture, I want to show you just a quick introductory video, and then we'll pause, and then I'll come back and we'll go ahead and start with this morning's lecture. So here we go.
Holding a vigil for the 20-year-old man who was shot and killed by a neighbor who thought he was an intruder. That deadly confrontation happened on Primrose Avenue. Now, since we first told you about this story at noon, NBC4's Tony Shin spoke with the family of the man who was shot, and they're telling a very different story. Tony is live right now in Rialto with that part of our coverage tonight. Tony?
Colleen, family and friends right now are praying outside the family home. They have gathered out here basically as a sign of unity. They say the shooting that killed 20-year-old Andy Garcia was not justified. They call it murder.
Feels like a big heart that everybody can see.
Miranda Garcia can barely talk as she remembers her big brother Andy.
We were always together, always tell each other like how we felt about things.
On Saturday, Andy was at a party at his family home on Primrose Avenue, celebrating Miranda's graduation from high school, when he got into a confrontation with Miranda's boyfriend.
My son is overly protective of his sister.
Family members say Andy had been drinking, and they knew they had to defuse the situation.
They decided to drive him to his grandma's house.
But seconds after leaving the home, Andy, who wasn't wearing shoes, jumped out of a cousin's car and ran toward a neighbor's home 3 doors down.
Seconds after, that's when we heard the gunshots. It was clap, 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 clap.
Rialto police say Andy had jumped over a fence into a neighbor's backyard. The homeowner told police he grabbed his gun as Andy tried to break inside.
To the extent of how far he got into the residence, I can't comment on, but we do have evidence of the location that indicates that there was a physical confrontation.
Andy was found dead in the backyard. Family members believe the homeowner overreacted and shouldn't have used deadly force.
We didn't hear no yelling, nothing. All we heard was gunshots.
As for Miranda, her graduation day will now be remembered as the day her older brother was shot and killed.
We miss him so much.
And we want to point out that we tried to contact the neighbor involved in this shooting, but over the weekend, his family actually moved out of the home. This case will now be sent to the district attorney's office for review to see if it, in fact, was a justifiable shooting. Reporting live in Rialto, I'm Tony Shin, NBC4 News.
Okay, well, welcome back, and hopefully you were able to hear the video. Okay, I know the sound was a little bit low, but I think everybody was able to hear it. So I want you to kind of think about the video and just hold that in the back of your mind until we get to the portion of the lecture where we're going to talk a little bit about the discretion to charge. But Chapter 12, again, we're going to look at several different things. So what are the steps? We're going to start with this. What are the steps in the criminal justice system or process? Let's say from arrest to sentencing. And is it just 2 or 3? Is it 10? What if it's a misdemeanor? What if it's a felony? What if partway through somebody pleads guilty? What if there's a plea bargain? I mean, there's a lot of different aspects to it. I think it's a lot more technical than most people are aware of. So I'll help you to get started. What comes after somebody is arrested? They're in the process. What immediately follows? Are there certain things that have to get done within a certain time? And who's in charge of doing those? So this is a smaller version of the city of San Diego, their process. And they have this on their website. And because it was an agency so close to us, I figured it would be a good one for us to use. When we talk about mapping the criminal justice system from arrest, whether it be a warrant or an arrest without a warrant, at some point this case is going to go to the DA, which is going to be the district attorney in the jurisdiction in where the crime occurred. So here's a closer look, a little bit blurry, but closer. So it's going to go to the district attorney. And, if there's no prosecution, then the case will stop there if there's a decline for prosecution. And in some places, we know that it might go to a grand jury, or it might be filed by a complaint. But if it goes to a grand jury, so we know there's two ways to file charges. One would be through an indictment, and then another would be through the filing of a complaint. The case is issued and a complaint is filed. So if we go this way, we have the grand jury where they don't indict or they do. And if they do, it starts to go this way. But the standard way, especially for California, is the case goes to the DA. And if the case is issued, there is an arraignment on the complaint. And if it's a misdemeanor, typically it's a guilty plea where there's an agreement reached and then sentencing comes quickly. But if it's not guilty, then it goes down to here to the felony disposition where they talk about a few, possibility of a deal and all those other things like that. Then you have the preliminary hearing, and we'll talk about what that is. And it could be dismissed at preliminary hearing because there may not be enough evidence. And then it could be, it could go to a not guilty plea, motions and hearings. And it could keep going, or there could be the charges dismissed. And it could be all the way to a guilty plea, then finally a trial, guilty sentencing, or not guilty. So, it can be very confusing. There are so many steps. So what we're going to do with chapter 12 is we're going to look at some of the early steps of the pretrial process, meaning before the trial, all that stuff that happens, and there actually is a lot of stuff. We're going to spend a couple of minutes talking about this thing called prosecutorial discretion. We all know what discretion is, right? It's the ability, or the you're given the ability to either do something or not. It's kind of discretionary, and it falls within the purview of the rules, the law, etc. We'll also talk about the filing of criminal charges and a little bit about probable cause when you're talking about detaining an individual. The defendant's first appearance before a judge, what happens? Release and bail. Can you get released before your trial? And if you can, what are some of the ways that occurs? And then finally, talking a little bit about the right of a person who cannot afford an attorney to have an attorney appointed to represent them. Okay, so that's the word indigent, but we're just going to say it in a classier way and basically say someone that may not be able to afford an attorney. Okay, so that's what we're going to look at. And as we go through this, you're going to see some nexus, some connection with the different amendments. So in earlier chapters, we discussed the investigation and detection of crime by law enforcement through things like searches and seizures, or through interrogation and identification. Once the police have completed their investigation, they have to decide whether to formally arrest a person and then to turn that person over, or the case over, if you will, to the prosecutor. And they may decide to drop the case and continue the investigation because of a belief that the suspect is not guilty, or because they lack evidence, or maybe even because they consider the crime to be fairly minor violation of law. The police may also decide to continue with their investigation and to focus on other suspects. In some instances, the police may conclude that a warning will deter a person from violating the law in the future, or that a defendant already has spent enough time in jail to provide adequate punishment. So we're going to look at a couple of different things in this chapter. We're going to examine the pre-trial and the trial and the appeal stages of the criminal justice process. So we're going to kind of initially look at the pre-trial release and what happened. So let's look at a couple of amendments first. So the Fifth Amendment talks about no double jeopardy, meaning that you can't be tried for the same crime twice. Remember, the same crime. The privilege against self-incrimination, meaning that you do not have to testify against yourself. And there's also some due process built into the Fifth Amendment that talks about no deprivation of life, liberty, or property by the government without this due process of law. Okay, so remember that, especially when it comes to the Fifth Amendment. And then the Sixth Amendment talks about or establishes requirements for criminal trials. And this is a speedy public trial by an impartial jury. And we'll talk about juries later, of one's peers, meaning of the makeup of the city, if you will. To be informed of the nature and the cause of the accusation, the crime, the charges against you. To confront and be able to cross-examine witnesses against you. To utilize the subpoena power of the court in order to subpoena witnesses in that defense, in your defense. And then finally, to be represented by legal counsel. And then the Eighth Amendment, talking about no excessive bail or excessive fines or moreover, even things like cruel and unusual punishment. And this typically deals more with things like the death penalty, but in the times that we have gone through, and at the time of this video, we still might be in a little bit, which I think we are, the cruel and unusual, the Eighth Amendment. What about the COVID-19 thing and those that are in custody, let's say in prison? Could this be an application of the Eighth Amendment? So I'm just kind of throwing it out there for us to, again, kind of consider. But with that being said, we're going to look again at prosecutorial discretion and the filing of criminal charges. So let's kind of jump into that. Oh, and the 14th Amendment, sorry. I always slide that in there. And looking at the right side of the 14th Amendment here, I kind of broke it up. We have on the left the selective incorporation doctrine, but we want to really focus in on the due process issue. No deprivation of life, liberty, or property without due process, including the Equal Protection Clause stating that all people are created equal, therefore no denial of this equal protection under the 14th Amendment. So one of the big cases that's going to come at the forefront, and we're not going to watch a video on it, but I want you to know, would be the Gideon versus Wainwright case. Now, Clarence Gideon was charged in a Florida state court with having broken and entered into a pool room with intent to commit a misdemeanor. And this offense is basically a felony under Florida law. Appealing in court without funds and without an attorney, Gideon asked the court to appoint counsel for him. And the judge basically replied like this: Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when a person is charged with a capital offense or a felony. I am sorry, but I will have to deny your request to appoint counsel to defend you in this case. So, put to trial before a jury, Gideon conducted his defense about as well as he could, or as well as could have been expected from a layperson. And he made an opening statement to the jury, cross-examined witnesses, presented witnesses in his own defense, declined to testify himself because he doesn't have to, and made a short argument emphasizing his innocence to the charge contained in the information filed in the case. And the jury in this case returned a verdict of guilty, and he was sentenced to serve 5 years in state prison. Well, as this case went through the system and ended up going to the U.S. Supreme Court, the case was overturned. Because if you go back and you read some of the amendments that we just talked about, we are entitled to an attorney when we are involved in an adversarial process, like a court case, not an infraction like a ticket, okay? But we're talking about, in this case, it was a misdemeanor, although, again, Florida law said just a felony. So I have a couple of videos that you can watch on that. And then this is a little longer video. It's more of about a 30-minute documentary, but it's done very well, and it lays out the Gideon versus Wainwright case. And I think you would find it very interesting. So again, as we looked at in early chapters, we looked at the investigation and detection of crime through search and seizure and through identification and interrogation. And as I said, once the police have completed their investigation, they're going to have to figure out or decide what's their next step. Now, they may formally charge the person and then turn the case over to a prosecutor. And again, they may decide to drop the case and continue the investigation for a couple of reasons. One could be because of a belief that the suspect is not guilty and they want to keep working on it, or because they lack evidence and they need more time, or because they consider the crime to be very minor and it's not really worth going to trial over. And the police may also decide to, keep working on the investigation, but focus on other suspects to question them to find out, are they on the right track? Do they actually have the right person? But following a suspect's arrest, that responsibility now shifts to the prosecution, who is the government official responsible for enforcing the criminal law through the prosecution of criminal offenders. And the U.S. Supreme Court, specifically in this case, Justice Robert Jackson famously observed that the prosecutor is perhaps the most powerful person in the criminal justice systems, system. And think about that, and then start to think about the video that we looked at. And let's look at it again. The prosecutor is perhaps the most powerful person in the criminal justice system. And why is that? When we throw that statement out there, because why would that be? And I'll give you kind of a second to think about it. Why would they be considered to be the most powerful? Wouldn't it be like the cops, or the judge, or the jury? What do you think? And why do you think that? Well, the answer really is that because courts have recognized the authority of prosecutors to decide who is to be charged with a crime, what crime to charge, and whether to basically plea bargain a case. The prosecutor also has the discretion over whether to refer a defendant to a diversion program for substance abuse, or even psychological counseling, or for some other purpose, rather than to actually prosecute the individual. So think about that where that sits, that they have the authority to decide who is going to be charged, what the crimes are, whether or not to plea bargain or offer a plea bargain, whether to divert, let's say, an individual into some type of program, like a mental health program or a program for narcotics or something similar, or even to add or offer other punishments. So that's quite a bit of power, right? When you think about it. So in a very interesting case in Waite versus United States, the Supreme Court observed that the prosecutors retain broad discretion as to whether to prosecute. And they add a little bit more. So long as the prosecution has probable cause to believe that the accused has committed an offense defined by statutes, the decision whether or not to prosecute and what charge, again, generally rests entirely within his or her discretion. So that's pretty intense. Now, if we go back to the case that I showed you, the little video clip, and that video clip was a little bit one-sided, but it was a news clip, and I'll kind of feed you a little bit more. This was a case where there was a party at a house, and at the party, one of the individuals involved got in an argument with his brother, and he was extremely intoxicated. And they decided, in order to kind of quell the argument or to quash the argument, they would remove this individual from the house and take him either home or somewhere else. And while they were driving the individual away from the property, he basically jumped out of the vehicle, and this was during the evening hours, and he fled from the vehicle out of sight. Well, unbeknownst to the family, the person, and they looked for him a little bit, and they couldn't find him, but this individual jumped into a backyard of a residence and started banging on the door. And yes, he was intoxicated, but the resident did not know that. And at one point, and they later found out that the individual inside of the home had both a daughter and a wife, and both of them, one was in a wheelchair and one was extremely ill with another disease. I can't remember what it was. But in order to protect himself and his family, he obtained a firearm inside of his residence, which he was allowed to have, right? We're allowed to have that. And at one point, the individual was breaking in through the screen, through the metal security screen on the door, and then there were some shots fired. And then, yes, there are some different witness testimony, from the people in the house, what they heard, but nobody else, just the individual that did the shooting. And yes, the individual subsequently was killed. So this is a case of prosecutorial discretion, because after the agency involved, and this was Rialto Police Department, and they had their investigators come out and take as many statements, get as much physical evidence as they could, everything that they could find, they sent it to the district attorney. And this is where the discretion part comes in. Should they charge the individual in this case or not? And hold on to that. Think about it as we talk about some of this information, and I'll come back at the end. Hopefully I can remember and tell you whether or not the case was filed on the person or not. Okay, so let's kind of move on. So again, prosecutorial discretion to charge. And we just kind of talked about the Waite case. There's another example of kind of a this is the case that I showed you at the initial. Part of this prosecutorial discretion to charge and falling underneath the Waite versus United States case is also something called the presumption of regularity. And this means that the courts presume that in absence of clear evidence to the contrary, prosecutors honestly, fairly, and responsibly exercise their authority. Now, if they can show that there was, something different than that, then that can be brought up at trial. But typically in the Waite case, there is that presumption of regularity, where the courts again presume that in the absence of any very clear evidence to the contrary, that prosecutors when they use this discretion, that they will be honest, fair, and responsible as they exercise their authority. So an example of the prosecutor's exercise of discretion comes in a United States, in a case called Batchelder versus United States. And this is an example of discretion. And this is a kind of a weird example, but stay with me here and then kind of think about what you would do. So two identical federal statutes apply in this case. Each of these punish a felon who takes possession of a firearm transported across state lines. So again, two exact statutes. One statute has the penalty of 2 years, and one has the penalty of 5 years. So the prosecutor in this case charged and convicted Batchelder under the statute that carried the penalty of 5 years rather than under the statute that carried the penalty of 2 years. And the U.S. Supreme Court in this case upheld the prosecutor's exercise of discretion, explaining that there is no appreciable difference between the discretion of a prosecutor exercises when deciding whether to charge under one of two statutes with different elements and the discretion he exercises when choosing one of two statutes with identical elements. Consider that the end result of the decision in Batchelder was that the prosecutor was able to determine the amount of time that Batchelder potentially would spend in prison without having to explain or defend his actions. So, and some of you might think that's fair, and some of you might think that's kind of unfair. So, while the courts have recognized the discretion of prosecutors to prosecute or not to prosecute a case and to decide what criminal charges to bring against a person rather than to subject these decisions to review by a judge, there are several reasons that we're going to talk about why courts have adopted the view that the prosecutor's charging decisions are ill-suited for judicial review, meaning that why doesn't somebody else do it? And should the decision of the prosecutor be reviewed like all the time? So, what are some things that might influence which of the following statutes? Now, this is kind of talking again about the case we just kind of spoke of, about the United States versus Batchelder. What are some things that might influence, which one to pick? Did he use the magic 8-ball? I don't think so. Did he flip a coin? No, I think he may have looked at some other things, maybe the person's prior record, maybe the elements of the crime. Maybe he was only able to meet the elements in one case, in one charge and not in the other. Or maybe he felt that the penalty was better charged under the higher standard. So here, again, the prosecutor charged and convicted Batchelder under the statute that carried a penalty of 5 years rather than under 2. And the Supreme Court upheld the prosecutor's exercise of discretion. And, I asked the question a minute ago, but let's just, ask it again. Why have the courts recognized the discretion of the prosecutor to prosecute or not to prosecute a case, and how to decide what charges to bring against a defendant rather than subject these decisions to the review of a judge? And you could probably think of some reasons, but let's look at some. So here's a couple of reasons. One would be the separation of powers, because the prosecutor is a member of the executive branch and is charged with the responsibility for ensuring that the laws are faithfully executed. And judges are members of the judicial branch and really are reluctant to interfere with the daily decisions of the executive branch unless there is some type of constitutional violation to either a state constitution or, of course, the U.S. Constitution. So hopefully that kind of makes sense. And if you don't know what I'm talking about, there are three different branches, if you will, to our government: the legislative, the executive, and the judicial. So you can see that there's some separation of powers there. The next one under prosecutorial discretion would be the discretionary judgment. So a prosecutor typically considers a range of information when they decide whether to prosecute a case or not. And courts really lack the experience to evaluate the prosecutor's weighing and balancing of factors, the strength of evidence, the impact of the prosecution in deterring other crimes, the government's priorities for law enforcement, circumstances of the case, and the defendant's background and character. So discretionary judgment. And the U.S. Supreme Court ruled that although prosecutorial discretion is broad, it's not unlimited. So we have to kind of, understand that. Just really quick, a third area where when we talk about the discretion of prosecutors, and I want to make sure that we don't miss that, would be that of resources. A review of the prosecutor's decisions would really delay prosecutions and consume considerable time and energy in the overall court system. So with that being said, the U.S. Supreme Court has observed that although prosecutorial discretion is broad, it's not unlimited. And courts will step up and review a prosecutor's decision where there is, in fact, an allegation that the prosecutor engaged in one of two things. And there are some other things, but these are the big ones. And that would be selective prosecution or vindictive prosecution. And let's take a look at both of these, okay? And we'll start with selective. So selective prosecution is a violation of the Equal Protection Clause of the 5th and 14th Amendments. And it is based on the person's race, gender, religion, or exercise of their fundamental rights. And we'll look at a couple cases as we go further. So in the Waite case, a leading example of this protection, again, comes from Waite versus United States. And here, Waite protested the Vietnam War. And in this case, he wrote government officials stating that he had no intention of registering for the military draft. Now, Waite's name, along with the names of 133 other individuals who wrote the government refusing to register for the draft, was sent to the U.S. Department of Justice for prosecution. In each case, these individuals were warned by the FBI that they were required to register or would be subject to prosecution. Now, Waite nevertheless continued to resist the draft and was prosecuted for draft evasion. And he argued that this so-called passive enforcement system violated the First Amendment to the U.S. Constitution by targeting vocal opponents of the war for prosecution, while the government took no action against the other 674,000 non-registrants who had not written the government. Does that make sense? So basically, he complained and the other ones didn't. So the U.S. Supreme Court in this case held that in order for Waite to succeed in his claim of selective prosecution, he was required to demonstrate that the prosecutor's decision had a discriminatory effect and that it was motivated by a discriminatory purpose. So what precisely is required under this prong? Well, we'll take a look at it. So again, here in the Waite case, the defendant is required to demonstrate that the prosecutor's decision had a discriminatory effect and that it was motivated by a discriminatory purpose. Maybe how they look, or tattoos, or anything else. Remember, we talked about some of those, right? Race, gender, religion. Okay, so those are some of the discriminatory factors. So the two-pronged test that was looked at, first, whether individuals are singled out for a prosecution who are members of a particular race, gender, or religion, or who have engaged in the exercise of a fundamental freedom, while other similar situated individuals do not fall within the group, are not prosecuted. And then the second prong would be whether the prosecutorial policy is based on an intent to discriminate against the members of that particular group. So that's what came out of the Waite case. And that's the selective prosecution. So again, now, and I'm going to kind of leave this up to you. I'm not going to tell you the answer to the Waite case. I'm going to have you look it up and see if Waite was successful or did he fail to satisfy the burden. Was he able to demonstrate that the government prosecution policy was based on an intent to punish individuals, okay, based on what we just talked about? So take some time and look that up. But next would be vindictive. So we know what the selective prosecution, but now let's look at vindictive. So this is a violation of the Due Process Clause of the 5th and the 14th Amendment, and it includes things like malicious prosecution. So in vindictive prosecution, a prosecutor retaliates against a defendant who asserts his or her rights by bringing a more serious charge against the defendant. So does that kind of make sense? And courts have held that this vindictive prosecution is basically what we call patently unconstitutional. It violates an individual's right to due process of law and risks deterring other individuals from asserting their rights. So it's kind of, it seeks revenge by, let's say, filing a more serious charge because somebody wants to assert their right. So a couple of cases. The Blackledge versus Perry case. So here Perry was convicted of the misdemeanor assault with a deadly weapon. And Perry then filed a notice of appeal to a superior court in which, under North Carolina law, he was entitled to a new trial before a jury. In other words, in this second stage, the slate is wiped clean and the prior conviction is no longer recognized. So because of that, the prosecutor responded by filing a new indictment charging Perry with a felony assault with a deadly weapon with intent to kill and inflict serious bodily injury. And here, Perry then entered a guilty plea to the felony charge. So what do you think about that? Where, because Perry used the methods that were available to him, and he was entitled to do that, the attorney, when they filed the case again, they filed a higher charge. So here, the U.S. Supreme Court held that an individual convicted of an offense is, here we go, entitled to pursue his statutory right to trial de novo, which means new trial, without apprehension that the state will retaliate by substituting a more serious charge from the original one, thus subjecting him to a significantly increased potential period of incarceration, right? So the court held under these circumstances, there is a real likelihood of vindictiveness on the part of the prosecutor, and that the prosecutor had improperly filed a felony charge against Perry in this case. And that makes sense, right? Well, consider another case, because there's always a couple of, these get gray sometimes. So in another case, United States versus Goodwin, and this is 1982, it basically upheld the fact that prosecutors do have some reasons for changing the charges against a person, and as such, it can't be automatically assumed to be vindictive. So we still have the Blackledge versus Perry case, which talks about, again, the fact that he was able to get that, trial de novo, that new trial, without apprehension. And the U.S. Supreme Court ruled in his favor. But in the Goodwin case, the U.S. Supreme Court also said, yeah, we recognize that. But we also want to recognize the fact that there are reasons that there might be some changes in charges against an individual, and we can't automatically just assume that something is going to be vindictive because it takes place. And so we have two different cases, both extremely informative. So we're now going to kind of move into a little bit of the probable cause aspect, and we're going to talk about probable cause to detain. So the first step for a prosecutor following the arrest of an individual without an arrest warrant or formal indictment by a grand jury is a judicial determination of whether there is probable cause to detain the suspect for an extended period of time. And you know what? We're coming up on the 43-minute mark, so this might be a good place to stop. We don't have a whole lot more to cover, but because, there's just so much content, we'll stop here and make this part 1 to chapter 12, and then we'll come back in a couple of minutes and we'll do our part 2, and we'll talk a little bit about this case, Gerstein versus Pugh. So this will conclude part 1 of chapter 12.